Note that under the 2019 amendments on civil procedure, Rule 16 on motion to dismiss has been either deleted or transposed. So this recording will cover Rule 17 to Rule 19. Rule 17. Dismissal of actions. Section 1. Dismissal upon notice by plaintiff. A complaint may be dismissed by the plaintiff by filing a notice of dismissal at any time before service of the answer or of a motion for summary judgment. Upon such notice being filed, the court shall issue an order confirming the dismissal. Unless otherwise stated in the notice, the dismissal is without prejudice, except that a notice operates as an adjudication upon the merits when filed by a plaintiff who has once dismissed in a competent court an action based on or including the same claim. Section 2. Dismissal upon motion of plaintiff. Except as provided in the preceding section, a complaint shall not be dismissed at the plaintiff's instance, save upon approval of the court, and upon such terms and conditions as the court deems proper. If a counterclaim has been pleaded by a defendant, prior to the service upon him or her of the plaintiff's motion for dismissal, the dismissal shall be limited to the complaint. The dismissal shall be without prejudice to the right of the defendant to prosecute his or her counterclaim in the separate action, unless within 15 calendar days from notice of the motion, he or she manifests his or her preference to have his or her counterclaim resolved in the same action. Unless otherwise specified in the order, a dismissal under this paragraph shall be without prejudice. A class suit shall not be dismissed or compromised without the approval of the court. Section 3. Dismissal due to fault of plaintiff. If, for no justifiable cause, the plaintiff fails to appear on the date of the presentation of his or her evidence in chief on the complaint, or to prosecute his or her action for an unreasonable length of time, or to comply with these rules or any order of the court, the complaint may be dismissed upon motion of the defendant or upon the court's own motion, without prejudice to the right of the defendant to prosecute his or her counterclaim in the same, or in a separate action. This dismissal shall have the effect of an adjudication upon the merits, unless otherwise declared by the court. Section 4. Dismissal of counterclaim, cross-claim, or third-party complaint. The provisions of this rule shall apply to the dismissal of any counterclaim, cross-claim, or third-party complaint. A voluntary dismissal by the claimant by notice as in Section 1 of this rule shall be made before a responsive pleading or a motion for summary judgment is served or, if there is none, before the introduction of evidence at the trial or hearing. Rule 18. Pre-trial. Section 1. When conducted. After the last responsive pleading has been served and filed, the branch clerk of court shall issue, within 5 calendar days from filing, a notice of pre-trial, which shall be set not later than 60 calendar days from the filing of the last responsive pleading. Section 2. Nature and purpose. The pre-trial is mandatory and should be terminated promptly. The court shall consider a. The possibility of an amicable settlement or of a submission to alternative modes of dispute resolution. B. The simplification of the issues. C. The possibility of obtaining stipulations or admissions of facts and of documents to avoid unnecessary proof. D. The limitation of the number and identification of witnesses and the setting of trial dates. E. The advisability of a preliminary reference of issues to a commissioner. F. The propriety of rendering judgment on the pleadings, or summary judgment, or of dismissing the action should a valid ground therefore be found to exist. G. The requirement for the parties to 1. Mark their respective evidence if not yet marked in the judicial affidavits of their witnesses. 2. Examine and make comparisons of the adverse parties' evidence vis-a-vis the copies to be marked. 3. Manifest for the record stipulations regarding the faithfulness of the reproductions and the genuineness and due execution of the adverse parties' evidence. 4. Reserve evidence not available at the pre-trial, but only in the following manner. 1. For testimonial evidence, by giving the name or position and the nature of the testimony of the proposed witness. 2. For documentary evidence and other object evidence, by giving a particular description of the evidence. No reservation shall be allowed if not made in the manner described above. H. Such other matters as may aid in the prompt disposition of the action. The failure without just cause of a party and counsel to appear during pre-trial despite notice, shall result in a waiver of any objections to the faithfulness of the reproductions marked, or their genuineness and due execution. The failure without just cause of a party and or counsel to bring the evidence required shall be deemed a waiver of the presentation of such evidence. The branch clerk of court shall prepare the minutes of the pre-trial. Section 3. Notice of pre-trial. The notice of pre-trial shall include the dates respectively set for A. Pre-trial, B. Court-annexed mediation, and C. Judicial dispute resolution, if necessary. The notice of pre-trial shall be served on counsel, or on the party if he or she has no counsel. The counsel served with such notice is charged with the duty of notifying the party represented by him or her. Non-appearance at any of the foregoing settings shall be deemed as non-appearance at the pre-trial and shall merit the same sanctions under Section 5 hereof. Section 4. Appearance of parties. It shall be the duty of the parties and their counsel to appear at the pre-trial, court-annexed mediation, and judicial dispute resolution, if necessary. The non-appearance of a party and counsel may be excused only for acts of God, force majeure, or duly substantiated physical inability. A representative may appear on behalf of a party, but must be fully authorized in writing to enter into an amicable settlement, to submit to alternative modes of dispute resolution, and to enter into stipulations or admissions of facts and documents. Section 5. Effect of failure to appear. When duly notified, the failure of the plaintiff and counsel to appear without valid cause when so required pursuant to the next preceding section, shall cause the dismissal of the action. The dismissal shall be with prejudice, unless otherwise ordered by the court. A similar failure on the part of the defendant and counsel shall be cause to allow the plaintiff to present his or her evidence ex parte within 10 calendar days from termination of the pretrial, and the court to render judgment on the basis of the evidence offered. Section 6. Pre-trial brief. The parties shall file with the court and serve on the adverse party, in such manner as shall ensure their receipt thereof at least 3 calendar days before the date of the pretrial, their respective pre-trial briefs, which shall contain, among others, a concise statement of the case and the release prayed for. B. A summary of admitted facts and proposed stipulation of facts. C. The main factual and legal issues to be tried or resolved. D. The propriety of referral of factual issues to commissioners. V. The documents or other object evidence to be marked, stating the purpose thereof. F. The names of the witnesses, and the summary of their respective testimonies, and G. A brief statement of points of law and citation of authorities. Failure to file the pre-trial brief shall have the same effect as failure to appear at the pre-trial. Section 7. Pre-trial order. Upon termination of the pre-trial, the court shall issue an order within 10 calendar days, which shall recite in detail the matters taken up. The order shall include A. An enumeration of the admitted facts. B. The minutes of the pre-trial conference. C. The legal and factual issues to be tried. D. The applicable law, rules, and jurisprudence. D. The evidence marked. F. The specific trial dates for continuous trial, which shall be within the period provided by the rules. G. The case flow chart to be determined by the court, which shall contain the different stages of the proceedings up to the promulgation of the decision and the use of time frames for each stage in setting the trial dates. H. A statement that the one-day examination of witness rule, and most important witness rule under Administrative Matter No. 3-1-9 SC, known as the guidelines for pre-trial, shall be strictly followed, and i.e., a statement that the court shall render judgment on the pleadings or summary judgment as the case may be. The direct testimony of witnesses for the plaintiff shall be in the form of judicial affidavits. After the identification of such affidavits, cross-examination shall proceed immediately. Postponement of presentation of the parties' witnesses at scheduled date is prohibited, except if it is based on acts of God, force majeure, or duly substantiated physical inability of the witness to appear and testify. The party who caused the postponement is warned that the presentation of its evidence must still be terminated within the remaining dates previously agreed upon. Should the opposing party fail to appear without valid cause stated in the next preceding paragraph, the presentation of the scheduled witness will proceed, with the absent party being deemed to have waived the right to interpose objection and conduct cross-examination. The contents of the pre-trial order shall control the subsequent proceedings, unless modified before trial to prevent manifest injustice. Section 8. Court-annexed mediation. After pre-trial and after issues are joined, the court shall refer the parties for mandatory court-annexed mediation. The period for court-annexed mediation shall not exceed 30 calendar days, without further extension. Section 9. Judicial dispute resolution. Only if the judge of the court to which the case was originally referred is convinced that settlement is still possible, the case may be referred to another court for judicial dispute resolution. The judicial dispute resolution shall be conducted within a non-extendable period of 15 calendar days from notice of failure of the court-annexed mediation. If judicial dispute resolution fails, trial before the original court shall proceed on the dates agreed upon. All proceedings during the court-annexed mediation and the judicial dispute resolution shall be confidential. Section 10. Judgment after pre-trial. Should there be no more controverted facts, or no more genuine issue as to any material fact, or an absence of any issue, or should the answer fail to tender an issue, the court shall, without prejudice to a party moving for judgment on the pleadings under Rule 34, or summary judgment under Rule 35, motu proprio include in the pre-trial order that the case be submitted for summary judgment, or judgment on the pleadings, without need of position papers, or memoranda. In such cases, judgment shall be rendered within 90 calendar days, from termination of the pre-trial. The order of the court to submit the case for judgment pursuant to this rule shall not be the subject to appeal or certiorari. Rule 19. Intervention. Section 1. Who may intervene? A person who has a legal interest in the matter in litigation, or in the success of either of the parties, or an interest against both, or is so situated as to be adversely affected via a distribution, or other disposition of property, in the custody of the court or of an officer thereof may, with leave of court, be allowed to intervene in the action. The court shall consider whether or not the intervention will unduly delay or prejudice the adjudication of the rights of the original parties, and whether or not the intervenor's rights may be fully protected in a separate proceeding. Section 2. Time to intervene. The motion to intervene may be filed at any time, before rendition of judgment before the trial court. A copy of the pleading in intervention shall be attached to the motion, and served on the original parties. Section 3. Pleadings in intervention. The intervenor shall file a complaint in intervention, if he or she asserts a claim against either or all of the original parties, or an answer in intervention, if he or she unites with the defending party in resisting a claim against the latter. Section 4. Answer to complaint in intervention. The answer to the complaint in intervention shall be filed within 15 calendar days from notice of the order admitting the same, unless a different period is fixed via the court.